And that's for you, yes. Judy, everybody's had the opportunity to look at your application. We appreciate it. It contained a lot of good information. What we'd like you to do is give us a little bit about your background, the areas that you practice in. One of the questions is, you were, according to the application, you were admitted to the Florida bar in 2003, but you've been practicing law for 19 years.
I was admitted in 1993.
No, the application's in 2003. I don't know. I'm not being critical. Because I usually correlate.
That's ingenuity.
No, because, well, no, that got
Well,
me
it does
going.
make me 10 years younger. That's
Yeah.
not a bad thing.
I've incorporated it now in my applications. And why you think you'd be a good circuit judge.
You want to hit all of that at one time? Or?
And if you forget any of them, don't worry, we'll come back and ask you about
All right, very good. Well, thank you. Members of the commission, I am Judith Lane. It's my sincere privilege to be here before you. I want to start by thanking all of you for taking the amount of time that you do. I know everybody comes up and thanks you, but this is a volunteer endeavor, and you have your hands full over the next 2 years with a lot of positions to fill, and I appreciate it on behalf of the bar and our community. I've been giving myself a lot of time to think about what qualifications go in to making a good judge. It's different at the appellate level than it is at the trial level, and it's very different, actually. At the trial level, I think what it takes to be a good judge is decisiveness, some walking around, common sense. I think you need exposure to many types of people. And I think you need to be efficient with your work and your caseload because you have a number of cases to manage. And I think you need to be fair, of course, ethical, and act with impropriety at all times, and propriety at all times. I think that at the appellate level it's much different. We need somebody with great intellect and writing abilities. But I gave that a lot of thought because I wanted to know which type of judge I wanted to be, at least to start out, and I wanted to assure you that if I didn't have all of those characteristics, I wouldn't be here before you. I would not have submitted my application, and I would not have taken up your time today if I didn't think I was among the highest caliber of the candidates that you will see. I think you need some walking around sense because, quite frankly, the judges on our trial bench now are exposed to a number of different types of cases. At any given time, the chief judge may ask you to be assigned to a dependency case, a criminal case, a family case, a civil circuit case, and no lawyer out there has handled all of those. Many times, judges will experience lawyers that come before them aren't prepared, so I think you need to have a gut instinct for the law because you're making quick, decisive decisions. And so I think you need to have a sense of what's right and wrong before you even hit the books. And I think you need to be able to take the time to make a decision and not be afraid to make a very hard political decision sometimes. We've seen the attack on the judiciary of late. We've seen Judge Will in the paper when he upholds the exclusion of evidence in a proper forum and he gets lambasted in the paper. We saw the Terry Schiavo case. A judge actually ruled contrary to his own spiritual values that Terry Schiavo had the right to end her life at the time without a living will. And we've seen Judge Graham, whose position this is, be spoken about quite frequently as a result of the Southeast Volusia Hospital Authority case. And so with each of those, they were very political, but you have to be bold enough to make the hard decisions. If you'll assist me, those are the criteria I think that make a good judge, and those are the criteria that I believe that I have and that I would like you to consider when evaluating my candidacy. A little bit about my background. Predominantly now I'm a commercial and business litigator. About half of what I do is employment law. The other half is a mixture of complex commercial litigation. It includes real estate litigation, estate litigation, contract litigation. It includes a little bit of probate and guardianship litigation, and a lot of business litigation, non-compete agreements and the like. My My career has evolved over the years. I did start practicing in 1993, not 2003, and I began by working with my mentor, my first mentor, Jacqueline Griffin, on the 5th BCA. There I was exposed to probably every type of law you can imagine. Certainly any law that would become before a Florida trial court as a court of first resort prior to appeal. I was assigned the opportunity and obligation to evaluate all the briefs from some very fine lawyers, criminal and civil, prepare memorandum, assist in writing opinions. It would include business law, it included dependency cases, of course, and termination cases, it included criminal law, it included family law, it included every aspect of every case that would come before trial court before appeal. It was that experience that gave me pause. When I originally got out of law school, I thought I wanted to be a criminal lawyer. And it's not that I lacked any passion for that, but I was exposed to so much variety that I didn't want to limit myself that way. And when I found an opportunity to work for a firm in town that would allow me to have a breadth of experience in many types of law, I did that. When I went to Smith & Perkins with Mr. Smith and some others, I started working for David Hood, and I was predominantly doing business litigation. But the firm there appreciated the fact that to have happy lawyers, lawyers need to do what they want to do, and they encouraged me and allowed me to grow and choose an area of law that I wanted to focus on that suited my personality and then would also complement the firm's repertoire. And at the time, the ADA, the FMLA, the Title VII and Florida Civil Rights Act were relatively recent statutes, and we were seeing a real growth in litigation in those areas, and I recognized that it was an opportunity for somebody to come along who knew a fair amount about those. I never elected to specialize in that field, and I didn't simply because I didn't want to limit myself to employment law alone. It's interesting, and I like it very much, but I like experiencing different types of law, so I can't honestly say that more than 55% of my caseload is employment law. But it's been a wonderful opportunity to know and be able to advise clients, because that has evolved into representing business clients for the most part on a much larger scale on all business matters. And so as of late, as I've aged and my clients have aged, I've actually become more of an in-house counsel to a number of businesses in the area, to where they call me on a number of matters related to employment law, commercial law, real estate, and the like. And so my practice has expanded. Larry Stout would say that I'm a general rag picker, if you would, in the sense that there's not much that I'm afraid to take when it walks into my office. I enjoy when something new comes in, the intellectual stimulation of a new substantive area that falls within the rules of civil procedure at least. I don't dabble as of yet in the family law rules or the criminal procedure rules, but certainly could. But anything that's civil or administrative law, I'm comfortable and I enjoy very much doing it.
If the chief judge were to say, you've been appointed by the governor, and were to say, well, we'd really like to put you on a criminal docket, and we would like you to get death qualified, would you say, well, I'm happy to do criminal, but I don't want to get death qualified?
I wouldn't want to personally be death qualified for me, but otherwise, no. I would be happy to do that. Happy as you can be. It's an ominous burden, and I would take that burden seriously, but I don't have political convictions against that, if that's the question. One of the things that intrigues me, and one of the reasons I want to do this and I want to do it now, is the notion that if you were to experience everything that the trial court had to offer, if you were a probate judge, a criminal judge, a family law judge, a circuit judge, a dependency judge, if you did all of those for 2 or 3 years, you're looking at a 15-year body of work by the time that you did that. And I don't think I would want to do any one of those for 30 years, but all of them are intriguing for a period of time to learn something new and have that exposure.
Do you see yourself, let's say after 15 years, wanting to go to the appellate level?
I think it's very hard for anybody to know. In 15 years, I try to set goals. 5 to 10 years out, I do think that's a possibility. I don't see that as something I want to do in 3 years. I want a full breadth of what the trial court has to offer, and I would like to do that. But there are many fine lawyers that I had the privilege of spending time practicing with. David Monaco being one, Rick Orbinger being another, that spent years on the bench and afterwards ascended to the appellate court. So I think that's a possibility, but certainly not until I learn to do the trial court job, if I'm fortunate enough to have it well complete and leave a legacy of work that is well learned.
You know, in your comments about being a generalist rather than a specialist in this position is going to be a dependency. I think you know that, and which is going to be, we're hoping that you will commit to 2 years in the dependency court, so we know we're not going to have to go through this again for a dependency court. But do you think you'll tolerate well or enjoy well? I don't ask you to enjoy dependency, but going from being enjoying being a generalist into being the most specialized of the specialists?
Yeah, I do. I mean, I've anticipated that question. I've had the opportunity to visit with Judge Case at some length. I've actually sat for a few days now in her courtroom to see dependency. And I'm not a stranger to dependency by any means. I mean, I handled a number of dependency matters when I was a law clerk. Probably, I would say 20 or 30 opinions were written during that period of time, or if they weren't written, there were opinions that were potential PCAs. I've actually been, for a short period of time, my husband and I were actually foster parents, so I understand that side of the equation from DCF. I'm a guardian ad litem now. Judge Beck has appointed me. I've done that intermittently throughout my career, so I know the guardian ad litem, a focus of Chapter 39. I've looked at Chapter 39 to see if it's changed. It's still abuse, neglect, and abandonment. And so I think it's something that, one, I could manage, I could learn. I talked to Judge Case about that. She said it took her 1 year and 3 months to really feel like she knew what she was doing. And now they're moving her after 2 years. And I watched her the other day, and she's fabulous. And for whomever gets that appointment, it's going to be big shoes to fill. But I relish the opportunity to do that for a few years. I don't think I could do any good for a year. I think you need to do something for several. Is it something I want to do for 30? Probably not. But if the chief judge needs me or the community needs me to do that for 3 to 5 years, I would like that. At some point, I think it would become intellectually unstimulating and I would move. But I'm not, despite my commercial experience, I'm not ready to jump into a bunch of discovery disputes over interrogatories and requests to produce on a trademark infringement case either. So I think the dependency court, in looking at it and in speaking with Judge Case,